Number 62, United Jewish Community of Blooming Grove versus Washingtonville Central School District.
Good afternoon, and may it please the court, Robert Rossborough with Whiteman, Osterman, and Hanna for the appellants. I'd like to reserve 3 minutes, if I might.
Yes.
For hundreds of thousands of non-public school students across this state, including the Orthodox Jewish students who are at issue in this case in particular, the legislature's guarantee of equal transportation has been lost. For public school students outside of New York cities, they receive transportation to and from their schools each and every day, safe transportation, reliable transportation. New York mandates that non-public school students also attend school each and every day to ensure that they're getting a substantially equivalent education.
Why is it that the law requires whenever the public school students are being transferred, those who are not in public schools are also being transferred? And that's it. That's the equality. That's the sufficient transportation you've offered.
Because two reasons, Judge. First is sufficient in the language of the statute qualifies the means that must be provided. There must be sufficient buses, there must be sufficient drivers to provide the mandatory transportation. And second, when the legislature adopted this statute, first in 1936, it did so to solve a problem. The problem was that the New York Constitution...
But what about the amendment that creates those additional days in the city? Doesn't that sort of, it strikes me that's a hard hill for you to climb. That seems to resolve the dispute here. The legislature would have done the same for outside of New York City if that was the intent.
It doesn't, and there's a reason why. Starting in 1981, when the legislature amended to add the centralized pickup portion of the statute, there was an express representation made by the New York State School Boards Association that this transportation outside of the city was being provided on days public schools are closed. That's in the bill jacket. The sponsor to that legislation then responded to that comment and questioned, how is it done on these days that the schools are closed, the public schools are closed, but the transportation still has to be provided? And that informed everything that happened in the early 1980s. From 1981 on, there were a number of bills that were proposed.
But why isn't it contrary to your view when the law was changed for New York City to provide for extra days, and then the schools outside of districts, there was an attempt to make a change, to make a requirement that failed more than once?
Well, because there are two very different systems of transportation that the legislature has enacted. There's one for New York cities, and there's one for the communities outside of New York
When
cities.
this was initially enacted in, I forget if it was 38 or 39, 1A, I thought that it applied to everybody, right?
So it did.
And that's what the text suggests. And then I thought that, but correct me if I'm wrong, that 1C was eventually added, which treats city school districts differently, correct?
Correct.
But I take it your argument is that the 1985 amendment applies only to the central school districts. Is that correct? Sorry, to the city school districts, right?
Well, it only applies in New York City in particular. It doesn't apply to the city school districts outside
sorry,
of New
that's
York
what I meant by city,
Correct.
the New York City school districts. But I don't understand how that could help you interpret what the legislature meant when it enacted in 1A a provision that applies to everybody. Wasn't it understood that the system at that point was relatively unitary and there was no differentiation between central and city school districts?
In 1985.
No, in 1939 is
In
what I'm
1939.
asking.
So in 1939, there was an understanding by the city school districts that this obligation did not apply to them.
And where do we find that understanding in the record?
So it's in the bill jacket for the 1939 legislation, and there's comments by city school districts from across the state. I saw at least twice, where they say the requirement that this budget for this transportation be done in an annual meeting of the district, and there is no annual meeting of the district of the city.
But
So their argument
the
was
language
this didn't
of the
apply.
statute, I think it's fair to say, but tell me if you have a different view, doesn't distinguish between city and central school districts.
Correct. And I think that the problem then arose over the 20 years of application before we got to 1960, when the mileage restrictions were imposed. That in 1960, the governor only approved that legislation because of his understanding that it would be amended to exempt the cities because of the problems that they had seen over the first 20
I
years of
read
its
that
application.
history as the city schools and some of the sponsors saying it never applied to them, and we're just going to make that clear.
Correct, correct. And that's clear in the AG's statement in support of the bill that's in the bill jacket, that this was never meant to apply to New York cities.
Well, to any city,
Sorry,
to any city.
in the city.
No, to any city, including
Yes, well,
Buffalo,
correct,
Syracuse,
correct, to any
Rochester.
city.
Any city
To
school
any
district.
city. So really, we have three very different transportation regimes. We have one for New York cities, which is just the voluntary, and then New York City has very specific restrictions on what they can do and what they can't do if they choose to provide transportation, because transportation in the city is very different from New York's other cities. So in the beginning, and from 1961 on, we've got these two different transportation regimes.
Is there anything in the record, I assume it would be the bill jackets, or maybe it's an SED document, that speaks to the practice with respect to the central school districts and whether they were providing transportation on all days in which the public schools were not in session?
So the only thing that I found specifically addressing that in the record, or in the bill jacket, is in the 1981 bill jacket for that centralized pickup point. That is a New York State School Boards Association letter that specifically says their concern with that provision was, well, we're going to have to keep our buildings open to make sure that this centralized place that the non-public school students can come will work. But they specifically told, and then the sponsor of that legislation responded, that those services are generally being provided throughout New York on days that the public schools are closed.
So, Counsel, your reading of 1A is that everyone other than city school districts is required to provide this equal transportation.
That's correct.
But isn't there a problem with the later attempt to amend 2A where they were going to include non-city school districts and they took it out?
Well, so in the 1999 and 2001 amendments that the respondents have pointed to, why that was taken out is very ambiguous. First of all, the
I don't
language.
care. Let's put aside why it was taken out, but why was it included in the beginning? Because if your reading of 1A is correct, you don't need it. They already have to do this.
Well, and I think that may have been the reason it was taken out, but that's.
But there were all these letters in the file saying this will place an incredible burden on us that we don't have, and this will break our budget, and this will.
And that has been the consistent position of the school
But
district.
that's why they took the provision out, is the natural reading of that, because they didn't want that to happen.
Well, and I think the legislature has provided for that in the statute. In the statute, the legislature says that this transportation is an ordinary charge upon the district. And 90% of that charge comes from state aid. The other 10% comes from the parents who pay taxes to the school district.
Under your reading, I take it, and I know this is not the case, but under your reading, the non-public schools could decide, for example, to hold classes all summer long during the 3 months that the public schools are not sitting, and if your reading is correct, the districts would have to provide transportation. Is that
That's
right?
not correct.
Well, what is it in the law that would make that not true?
The equal transportation requirement in the law is what makes that not true.
But then why doesn't that answer the question of whether it has to be provided on, it sounds to me that you're saying as long as there's a relatively small number of days on which the non-public schools are operating and the public schools are not, that transportation is required. But why would that not then include, for example, the whole summer? I don't understand what the limiting principle would be.
Well, the limiting principle is, as these legislative amendments have been discussed, and including in the legislative debate that was cited in the SED's compendium, there's a specific question of, wouldn't this amendment allow transportation during the summer and all of this? And the sponsor at that time specifically said, no, this is during the normal school year, September to June, normal school week,
But where
Monday to
is
Friday.
that in?
But that's-
if
yeah,
not
is that a
anywhere in the
statutory
statute.
command?
And I thought, in fact, these petitioners asked for 2 weeks in the summer.
No. So there were 2 days at the beginning of August when there were superintendent conference days, our understanding the public schools were open, that the non-public schools had started their calendar. The last 2 days of August, the 30th and 31st in particular.
Council, can I ask that same question in a slightly different way? Let's just say the normal school year is 180 days long, and the non-public schools, including the ones that you represent, decided our schools are going to be open the other 180 days of the year when the public schools are not open. That's equal. It's still a school year. They're just allocated differently in terms of days. What is it in the current constitutional or statutory framework that would preclude, under your reading of the statute, a non-public school from making that decision?
Because that is not the transportation during the normal school year and normal school week.
But
that
where
is
does it
provided to
mention
public school-
normal school year? I don't see anything
Well, it's
about
because it's
normal.
to and from school that they legally attend. And legally attendance is understood.
It's illegal to open a school in the summer?
For the transportation purposes in this statute, the legal attendance in the schools is during the normal September to
That
June.
really seems to go to Judge Rivera's original point. Then why isn't it equal just on days the public schools are open? If you're going to tie it to the school year they're open.
Because what the districts are relieved of are providing these transportation on the different days of transportation that the religious schools and the secular non-public schools are closed.
But I don't
They're-
see then how you draw the line then if they want to open in the summer and it's 180 days that those schools are open.
Well,
Why are you taking the equal to mean the school year but not the days?
I think that the distinction here is that because the public schools are providing transportation during those times to the public school students, if it's different instructional days, within about the 180 days that is required for children to attend school, then the obligation would provide the
I
equality.
understand that might be reasonable to say that, but I don't see where in the statute that is laid out.
So, it may not be expressly there but the understanding of what the purpose of this statute was in the beginning was to ensure that students who were not getting transportation because of the fact that they went to a religious school would then be provided a safe and reliable means of transportation to ensure that they can satisfy the obligation that New York puts on all students, regardless of whether they go to public schools or non-public schools, to have an education that is substantially equivalent to the public school students. So to satisfy that obligation, the legislature chose to provide this transportation, and that was the remedial purpose that they tried to fix. I see my light is on. I will reserve my few minutes. Thank you.
May it please the Court, Beasley Kiernan for the State Education Department. State Ed has long interpreted Section 3635 as requiring central school districts to transport non-public school kids only on days when the public schools are in session.
Do we have to defer to that interpretation? Isn't this a question of the statute?
There's no need for the court to defer to State Ed's interpretation of the statute. State Ed's interpretation is consistent with the longstanding practical construction of the statute, and the court should defer to that. And the legislature has acquiesced in
I'm
it.
sorry, whose practical construction? I thought
practical-
you were saying it's yours.
State Ed adopted the practical construction given to the statute by the central school districts. As early as the 1980s, it was very clear that
I
central
thought it
school
was your guidance to them.
I'm not aware of any specific State Ed guidance before 1992, which we do include in the record, but I'm not aware of anything before that. It was just the settled construction. School districts were not transporting non-public school kids on days when the public schools were closed.
Does the statute specifically say that they must provide transportation when the schools are not in session or when they are in session?
No, Your Honor. The statute, the text of subdivision 1A applicable to central school districts, it's ambiguous because it does not direct central school districts when to provide transportation. But in context, the structure and history of the statute dispel that ambiguity. And the fact that subdivision 2A of the statute expressly directs New York City to provide 5 days of transportation when the public schools are closed shows that the legislature knows how to impose this kind of obligation, and it has done so expressly.
So where does the record tell us, I think I asked your adversary this question, so where does the record tell us what the practice was with respect to central school districts? You said that the practice was that they were not transporting students on days in which the public schools were not in session. So where do we find that?
The bill jacket, which is in the record,
For the, for the.
For the
nine-
1985,
Uh-huh.
that's the best support I have. For example, a letter from the New York State School Boards Association, this is on pages 161 to 162 of the record. They note the burdens that school districts would have to bear if they transported non-public school kids on days when the public schools were closed. It cites specifically Guilderland Central School District, which transported kids to 33 different non-public schools at the time. And even a limited 2-day requirement of transportation when the public schools were closed would have been burdensome on Guilderland. And so the legislature deliberately omitted this requirement that central school districts provide transportation on even a limited number of days when the public schools were closed. As the appellate division explained, the legislature thereby manifested its intent not to require central school districts.
So the bill jacket doesn't exactly say this, but is it fair to infer that part of the reason that the legislature acceded to doing this in New York City is that it essentially was no cost because students were largely getting cards allowing them to have passes on public transportation?
My understanding from the bill jacket is that New York City was actually providing subway tokens on days when the public schools were closed. And the question was whether New York City was going to have to provide bus transportation, which it ordinarily provided, I think, to elementary school kids at the time, on days when the public schools were closed. So it was a significant burden even on New York City. And the legislature chose to impose that burden and to expand transportation for non-public school children in New York City. It chose not to do so.
But not for every day, right? It's not
Right.
every day that a non-public school was open when a public school was not.
Yes, at the time in 1985, it was just 5 days, and the legislature spelled out which days the non-public schools could choose. In contrast, petitioners now are asking for a much broader obligation imposed on central school districts.
So how about that? I take it your adversary's position is that there's some limitation that is constrained to the months, more or less, that the public schools are in session. If we were to agree with your adversary's construction of the statute, do you think there's some limitation on that obligation, or could they, in fact, the non-public schools, in fact, for example, decide to, as I believe Judge Canataro asked, hold classes on the inverse 180 days?
Petitioners below asked for transportation whenever non-public schools are open.
But what's your
That's-
reading of the statute and the legislative history? Is there some limitation that lies there, or no?
I'm not aware of any explicit limitation on when school districts may transport non-public school students. I think a number of provisions in the education law imply that there's a normal school year between September and June. That's obviously been the practice for many decades. But I don't think there's any explicit limitation on when non-public
There are
schools
some
can operate.
limitations about the days, I'm sorry, there are some limitations about the days that schools can be open, though, right? Federal holidays, I think maybe Saturdays, those are exempted as school days.
That's right. Section 3604, subdivision 8, limits the number of days when schools can be in session, holidays, for example. Whether that applies to non-public schools, I think that's a fair question. The way Supreme
Is
Court,
that an open question?
in practice, if a non-public school opens on Christmas, I don't think state ed would do anything about it. There's no direct regulation of non-public schools in that sense.
But I assume you would argue they're not required to provide transportation on Christmas Day.
Of course.
The central school district.
Right, central school districts. Because of the legislature's acquiescence in this longstanding practical construction. In 1985, the legislature demonstrated its awareness that central school districts were not providing transportation on these days, and it rejected an attempt to impose even a narrow obligation to transport on 2 days. And the legislature has rejected several other bills through the years that would have required
Do you have a sense of this cost? I mean, Washingtonville gave an approximation of what it would cost. What would be the cost across the state if you have some sense of those numbers?
Even for Washingtonville, it would be a significant.
Yes, I saw
amount.
that.
I believe 14,000 is in the record per
14,000
day.
plus, yes, per day.
Across the state, it could be millions of dollars. And it's not just the cost, it's also the administrative burdens, especially for rural and suburban school districts that are transporting kids with their own buses to a lot of different non-public schools. They might have central pickup points, which have to be public school properties, public schools themselves. If a non-public school chooses to be open on days when the public schools are closed, that's dramatically expanding the kinds of services that.
Would there be any issues with your contractors who provide, well, not your, the school district's contractors who provide the transportation services? Or are they, to the best of your knowledge, willing to transport whenever they're needed, as long as they're paid?
It would certainly require negotiation with contractors, with unions. It would be an incredible administrative burden, and petitioners just have no basis in the text for this kind of request.
And just get back to this question of cost, even though you don't necessarily know the numbers. It is a 90-10 breakdown. State assistance 90%, 10 is the bill that's footed, let me put it that way.
That's right.
By the district, and it's not just the parents, correct? It's all the taxpayers in the district?
It's all the taxpayers in
It's
the
everyone,
district.
not just the parents. Okay, thank you.
That's correct, Your Honor. There's also no limiting principle to petitioner's request. I understand that petitioner schools are seeking transportation only on 20 days, which is itself a lot of days. But there's no limit to petitioner's interpretation of the statute. Petitioner's interpretation is directly contrary to the statute's longstanding practical construction that the legislature has demonstrated its awareness of, and it would impose an unbounded obligation on central school districts when the legislature deliberately rejected even a narrower obligation in 1985. State Ed's interpretation, by contrast, reflects the longstanding practical construction. It's consistent with the legislature's own view of the statute, and it doesn't read into the statute an obligation that the legislature deliberately omitted. Unless there are any further questions, I urge the court to affirm the decision below.
Thank you.
Thank you.
May it please the court, my name is Mark Rushfield. I'm the attorney for the Washingtonville Central School District. I don't think I need to repeat the various arguments you've heard from the SED. I just want to raise a couple of points in my few minutes. Counsel for the appellant's argument, and you've heard some of it here today, is that there's somehow ingrained in this process a normal school year, a normal school day, a normal school week. But what's normal for public schools, we know what that is not normal for the schools that the appellant's children are attending. It wouldn't be normal for lots of other kinds of schools. A Muslim madrasa, which could add academic courses, they would be open year-round, because that's how they operate. And under the appellant's interpretation of the statute, which, as we've all noted, would have no limitations. There's no normal school year. There's no limitation on the number of days. There's no limits.
I don't want to argue for your adversary, but wouldn't the argument against that be that that's not equal? A 365-day school year is in no way equal to the transportation being provided to public school
True,
students.
but the statute doesn't use the word equal, doesn't use the word normal. There is no standard in that you It's simply what, in terms of the argument that the appellant really has to make based on what language is there, it's if you are going to a school on a day that school is, that religious or any private school is open, the school district must provide transportation.
Well, why isn't that a definition of sufficient? If kids need to get to school, the school is open, you're required to give sufficient transportation.
Well, I guess if you had to give sufficient transportation, if sufficient transportation means every day a private school is open, and that can be not only 180 days, including the summer, but year-round, 12 months out of the year, then you would be right. But that's not, the statute doesn't really say that.
What if it's just swaps of the days?
I'm sorry?
What if it's just a swap of the day? It's always capped, let's say, with the 180 days per school term. They can't exceed that. They can't ask for 365 days.
Why not? The statute they can.
Say, if that was I'm saying, the interpretation of sufficient transportation,
But it doesn't, as I
that it's one for one day. The fact that the public schools may be closed on Christmas Day, but some religious schools do not recognize that as a religious holiday, so they are going to have school that day, but they have a different religious holiday when they are going to be closed.
well, of course,
But it never exceeds the 180.
of course, the problem that arises in such a circumstance.
sorry, what?
The problem that arises in such a circumstance, for example, goes to the issue again of cost, because as you knew from the records, it would be, at this point, it would probably be at least $300,000 a year for Washingtonville. But that doesn't include the fact that you
I'm
are-
sorry, to do what, 20 days? Just the 20 days?
That's just for the, well, yes, just for the 20 days.
Thank you.
But that doesn't include the fact that you're going to have higher, Washingtonville contracts it out, they don't do it in-house. But if you're making bus drivers and matrons on a bus have to work on Christmas,
Yeah.
you're going to be paying overtime costs. You're not going to be paying, you're going to be paying premium costs for travel. You're going to be paying premium costs toward that bus company having to be open that day. So the impact can be not only upon a school district, but across statewide, it's going to be really significant.
Do you know
A
whether
school could,
Do you know whether Washingtonville has ever transported non-public school students on public school holidays? Has ever done that?
for as far as I know, the answer is no. They have, certainly since the SCD guidelines, because there was also a district policy that followed those guidelines, which is in the record. It says that basically they transport only on days that the public schools are open, period, end of story. They can, as we all know, they can actually, a district can agree to do more. The question is it mandated? And I suggest that it's not mandated. It makes no sense for it to be mandated, not only for the various reasons that the court has itself noted. And my light's gone off. Thank you for your time.
Thank you.
Three points, if I might. The first is that you have to read the statutory mandatory obligation here that was adopted back in the 1930s in light of what it was changing. The legislature specifically said, and this court quoted in Judd against the Board of Education, that the purpose of this transportation was to ensure that the children who reside so remote from the schoolhouse in their school district, that they not be practically deprived of school advantages during any portion of the school year. That's in Judd, quoting directly
And
from the
that's the
language.
statute we declared was unconstitutional in Judd.
It was, but the purpose of the 1939 law conferred in the bill jacket was to readopt what had then been determined to be constitutional by the people of the state.
Adopt the exact same statute, though, right?
It adopted a statute that is virtually identical. All it did was change the purposes and make it mandatory. So the purpose was still contained that remote obligation, and then to ensure that this was done for the best interests of the children. The children needed safe and reliable transportation at that time, and that's what's being requested on the different instructional days. These are not additional instructional days, these are different ones. My clients' Orthodox Jewish schools close on 20 religious holidays that the public schools are open. They ask then for 20 different days of instruction when their schools are open and the others are closed. With respect to the 1985 amendment, the difference there is the voluntary versus involuntary legislative scheme that the legislature created for transportation. In New York City's, it is completely voluntary to provide transportation. They have to choose to do it. And if they choose to do it, then they have to provide these 5 additional days of transportation. That, in New York City in particular, that was an addition to rights that the children did not have at that time. For central school districts, it's different. This statute says that has
If
been.
they choose to do it, they have to do it equally, right? That's under C, I think. isn't it?
Correct. In like circumstances is the language that the legislature chose for that. The standard for central school districts outside of New York City is different. This is mandatory.
But doesn't that indicate the legislature didn't think equally meant that? C says equally, right? The language
Well,
is.
it says in like circumstances. And the legislative history, including the governor's approvals of a number of different amendments through this, is parity was what is intended.
Such transportation shall be offered equally to all such children. So equally is in C, and clearly when they used equally, they didn't mean on these other days because they had to do 2A to include those days, right?
Well, so for the purposes of that, they wanted to ensure that equal meant the transportation means to get there.
So equal may not mean on days the schools are open, because it didn't mean that in C, right?
Well, but that's where the difference between the two legislative schemes come in. The legislature has chosen to treat these two different classes of pupils differently. In the cities, there's available transportation through mass transit that can otherwise be used. In New York Central school districts and rural areas, that is not the case. That is not available. And so this transportation was made mandatory to ensure that the students have a safe,
But it does seem
reliable
a
way to get
bit
to school.
odd, does it not, given the millions in costs, given the administrative burden, that you would have some express statement in the legislation to clarify this. This debate has gone on for some time.
It's gone on for 80 years, and every time the debate is, the school districts say
I'm saying, one would think during that amendment process that if the legislature meant what you argue it means, that we would have crystal clear language on that, given the consequences of your interpretation.
That certainly would have been preferable, but I don't think it's necessary when you look at the original purpose of this statute. The original purpose of this statute, the remedial purpose of this statute, was to fix a problem. And that problem was that these students were not getting transportation to their schools, and their education was suffering as a result. The legislature wanted to provide the means to non-public school students to
Because
ensure.
they weren't getting transportation at all.
They weren't getting, yes,
Right,
correct.
so now they get transportation when the public schools are open, just like public school kids. They're treated just like a public school child.
But that's not like every public school child, because every public school child gets transportation to and from school every day their school is open. The non-public school children do not. My clients in particular are denied 20 days of transportation. That's a full month of school when you look at days of the week, that these children do not have a way to and from school. That's the problem that the legislature was intending to fix. And it did it through a mandatory obligation.
Well, that sounds very persuasive, except then we're back to the problem that means that your clients can redefine the school year.
But
Right.
and I don't think that's true, because of equality is what's required, and sufficient doesn't mean all the time. Sufficient is during the normal school week and during the normal school year, Monday to
So then
Friday.
what if a school has 30 religious holidays? 40, 50, 60, that are different?
If they fall, what the legislature has decided is if they fall within the
Or
normal
the school
week.
that's not public, but it is not religious either, right? It's a secular, non-public school.
Sure. In that case, if those days fall within September to June, then the public schools have an obligation to provide that transportation.
Including on Saturday and Sunday.
No, because under 3604 of the education law, the public schools are not allowed to provide transportation on those days. And actually, 3604 provides one additional point that I think I should mention. There's a provision at the end of it that says superintendent's days can be held in August. But you don't have to provide transportation, because it doesn't change your transportation obligations in August to provide that transportation, even though the public schools are open. That phrase has no meaning at all if it doesn't, the legislature wasn't also recognizing that during school day or conference days, when the public schools are closed and the public school students do not get transportation, that non-public transportation is still being provided, because otherwise that clarifying language would not have been necessary at all. 3604 says that. And what it shows is the legislature had an understanding, and it has an understanding since 1981, when the New York State School Boards Association told it that public schools were transporting these students on days that public schools were closed. And that informed all of the legislative history after it, and every attempted limitation on that has been rejected.
Thank you.
Thank you.